diversity, 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 diverse, diversity, diversity,
Diversity, diversity, diverse, diverse.
Diversity, diversity, diversity,
Diversity, diversity, diversity, diversity.
Diversity, 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 diverse.
Diversity, diversity, diversity.
In choosing a law clerk, do you believe that a law clerk applicant's race should be used to harm that person?
Neither to harm nor benefit, Senator. I believe that applicants should be considered based on their background and experience.
So you don't think a person's race should be used to harm them?
Correct, Senator.
You think a person's race should be used to help them?
Not in that context, Senator, no.
Okay. Raise your hand, please, for me if you're a member, a dues-paying member of the American Bar Association. So 2 out of 6 are members. Judge Becerra, why aren't you a member?
Senator, I was a member for many years of the American Bar Association.
Why'd you get out?
Honestly, Senator, when I was a member, my law firm paid the dues.
Yeah.
And so I don't pay the dues for the American Bar Association, but I was very involved.
Find
for
it
many years.
irrelevant and not worth the money?
No, sir. As you know from my record, I actually co-chaired the section of litigation
Right.
For a number of years, and I thought it was very beneficial as a lawyer.
But it wasn't important enough to you to pay yourself?
It wasn't so much that, Senator. It's just that many of the benefits of the American Bar Association, at least for judges, I'm already participating in what the administrative offices provide with training, which is really what I was doing as a
So it
lawyer.
was beneficial to you if somebody else paid for it?
No, sir. It's just that as a lawyer, I used it primarily for legal education.
Okay.
And as a judge,
I don't want to spend too much time on this. Just for the record, 2 out of 6 of our nominees today have chosen to be dues-paying members of the American Bar Association. Mr. Sherriff, how long have you been a member of the ACLU?
Senator, I believe I first contributed in 2019.
And how much money have you given them?
I believe it's approximately $100, $120
And
a year. I'm sorry.
A year?
Yes.
Okay. And why did you first decide to contribute to them?
Senator, I contribute to
Just briefly.
charitable organizations. They work on First Amendment issues.
Yeah. Now, you're a member of the ACLU of Southern California.
That's correct.
All right. A couple years ago, the ACLU of Southern California put out a statement. They said that U.S. policing has, quote, historical roots in slave patrols, close quote. And the ACLU chapter of Southern California went on to say that police presence has, quote, devastating and discriminatory impacts on tens of thousands of California students, close quote. You agree with that?
Senator, I'm not familiar with that letter. I have never seen that letter.
But I just read it to you. You agree with what that letter said?
I don't have information relevant to that.
You don't agree with it, or you do agree with it?
I can talk to my experience in law
No,
enforcement.
sir, I'm asking you if you agree, disagree with the statement of an organization that you chose to join
Right, Senator.
as an assistant United States attorney.
I understand, Senator. I would have to know a lot more about where that comes from in
Another
order to
letter
evaluate
said,
it.
well, you're not doubting that I'm reading it to you accurately, are you?
No, I'm not, but I don't know what the basis
Okay.
for that information is
The
in the letter.
ACLU of Southern California also put out another statement. They said, quote, ICE is not welcome here, close quote. Do you agree with that statement?
Senator, nearly 20 years in my practice in the Eastern District of California, the office has worked closely with ICE.
Do you agree with
and,
that statement?
certainly, in terms of federal law enforcement, ICE is welcome, and we work closely with.
Maybe I'm not being clear. Do you agree or disagree with the statement that ICE should be welcome in California?
I believe that ICE carries out a legitimate
legitimate
function under federal law.
I understand. Give me one more minute, Mr. Chairman. Let me ask Mr. Leibowitz. I want to ask you, it's a constitutional question. I think we now understand that there's some people in America, and I dare say many of our college students and college professors who believe, my words, not theirs, but this is what I see, who believe in diversity, equity, inclusion, and the right to kill Jews. To what extent is that point of view protected by the Constitution, and what, if any, limits are there on that point of view?
Senator, I very much appreciate the question, especially the times that we're living in. First, as your former colleague and now the president of one of the great universities in this country, the University of Florida, said, the First Amendment gives people the absolute right to be abject moral idiots. And Senator Ben Sasse, now President Sasse.
So does the Senate.
So I take part of your question that since October the 7th, I think part of what you are saying is that people are taking full advantage of their First Amendment rights. And the basic dividing line in answering your question, as I understand the court's precedents and the First Amendment, is that there's a very big difference between speech and conduct. There's a very big difference between things like Title VI, Title VII.
Let me stop you because I don't want to go too far over.
Yes.
I think you've made the correct distinction between speech and conduct. If I could have just 30 more seconds. Could the U.S. Department of Education, if a college professor crosses that line between speech and conduct, could President Biden's Department of Education withhold their federal funding?
Senator, I'm going to only be able to quickly answer part of your question. First of all, I do believe that part of the way you phrased it, I'm precluded from answering it because of the canons of judicial ethics, because there are live cases now and live statements now, as I understand it. There are live cases being brought under federal law tracking exactly what you're saying, and I'm not sure if the President's Department of Education wants to weigh into that or not, but if they did, and that case came before me, I wouldn't want my comments today to be viewed as prejudging them.
A few years ago, you wrote a law review article criticizing the Supreme Court's opinion in United States versus Morrison. As you'll know, it's one of only two instances in which the Supreme Court has struck down a statute as being enacted in excess of Congress's authority under the Commerce Clause. It did so based on a conclusion that the activity regulated in that case, acts of violence, were non-economic in nature. They were bare intrastate, non-commercial activity occurring in one state at one time, not part of any interstate commercial transaction, and not part of any channel or instrumentality of interstate commerce. You derided that decision as an instance of conservative judicial activism. You also said that it was a problem. You strongly disagreed with it. Can you tell me if you disagreed with the holding in Morrison, and the holding specifically that the Commerce Clause power can't apply to bare, intrastate, non-commercial acts of violence in that instance? What remains beyond Congress's reach under the Commerce Clause?
Senator, I thank you for the question. As you know from the question, let me start with the article. The article was written in 2000. It was written after Morrison and after Lopez. Those were the first two decisions since 1937
The only two?
Yes, sir. Yes, Senator. The only two since 1937 where the court struck down acts of Congress as beyond the commerce power. Lopez in 1995 was a very important decision because it was the first one, and to supplement what you said, Senator, there were three grounds why they struck down Lopez. There was non-economic activity. There was, does it invade a traditional state function? There was, what are the findings of Congress? Well, in Morrison, so there were three reasons why they struck it down in Lopez. Morrison, viewed by everyone, whether you agreed with the decision or not, really relied on the first one because Congress made explicit findings, voluminous findings in Morrison. The statute itself that was struck down was a civil rights statute, a civil liability statute, not something traditionally reserved to the states. So although you used the word that I criticized with my co-author, Morrison, we really didn't.
Wait, you're saying acts of violence are not historically reserved, covered by state law? I mean, tort law?
Senator, you're certainly correct the way—
Criminal law?
Yes, Senator, you're certainly correct the way you just stated it. That is state law. But the Violence Against Women Act, the provision that was struck down, was a civil liability provision that was akin to civil rights laws that were passed by this body. Civil rights laws like cases that were upheld in Katzenbach versus McClung and others. My only point, Senator, is that I don't think it's fair to say that my co-author and I were criticizing Morrison. We wrote at a time.
Well, it's generally regarded as criticism when you call it an act of judicial conservative activism. That's not a compliment.
I don't think that phrase is in keeping with the article. What I would agree with you, Senator, in saying is that the Supreme Court in 1995 and the Supreme Court in 2000 started to get more formalist in their categories. And in 2005, after we wrote the article, in Gonzalez versus Raich, the court did not go that far. They did not continue on the path that we were talking about.
Yeah, but Gonzalez versus Raich involved a different category, involved something, exchange of a contraband item for which there's an established interstate commercial market. And therefore it couldn't be regulated adequately absent comprehensive control by national authority. That's very different. By contrast, here's what you said in the article. This is an excerpt from it. Quote, if the court finds that all federal regulations of non-economic activity are equally precluded from the Constitution's limitations on congressional power, then such a decision would so violate social expectations and needs that it would likely require the court to turn to a different approach in order to define commerce power in a way that's consistent with the four corners of the Constitution and the pressing needs of growing a national and international society. I'm not sure what that means. I'm not sure what provision of the Constitution allows us to modify the terms of the Constitution based on social expectations and needs, or on the pressing needs of a growing national and international society. Moreover, the minute you open up the Commerce Clause to being applicable to bare intrastate non-commercial activity outside the scope of civil rights legislation enacted in 1964, which just as easily could have been defended as an exercise of Section 5 of the 14th Amendment, you're in dangerous territory. NFIB versus Sebelius doesn't count because the court went on to rewrite the law not just once but twice in order to save it from an otherwise inevitable finding of unconstitutionality. I don't understand what your approach is. How would you have written Morrison?
Mr. Chair, if I'm allowed to answer, Senator, if I'm allowed to answer with the time, I appreciate the question. I think I would have said this. There's a lot in your question, Senator. Let me first assure you that there is nothing in that article that should give, I believe, any member of this committee any pause that I will follow the law. If Morrison's the law, I'll follow it.
I'm not doubting that. I want to know the answer to my question.
Yes, sir. Yes, sir. So let me take that. And that's why I thought it was important that I said that we wrote it in 2001. After cases like Gonzalez versus Raich in 2005 and others, as you know, part of your question is that the court was seriously considering abandoning, Justice Thomas and others were thinking about abandoning the substantial effects test. That part of the Commerce Clause. I know, just having heard your question, Senator, that the substantial effects test bumps up against the 10th Amendment all the time. What I would say is—
But it swallows the 10th Amendment.
I take your.
But they didn't get rid of that. That's why I'm trying to understand what your analysis is here.
That's right. So what I would say is that after 2005 and other cases, the court has not abandoned the substantial effects test. And if I was so fortunate to be confirmed as a district court judge, I would follow what the Supreme Court and the 11th Circuit say. They allow, in certain cases, when evaluating acts of Congress, to determine whether they substantially affect interstate commerce. That is currently my understanding of the law, and I would follow it. But let me assure you, Senator, I think my background as an assistant United States attorney for 12 years, I think my background just as a lawyer in Miami, I don't think that you should have that your question, if it has a concern that I would be some roving judge that would take the commerce power and swallow the 10th Amendment whole, I would respectfully suggest that I would do nothing of the sort.
I get that. I just don't want somebody interpreting the Constitution based on growing societal needs instead of the text of the Constitution. Thank you.
I wanted to follow up on a question or two that Senator Kennedy asked you, because I wasn't sure that I understood your answers, but I bet you can clear it up for me. Let me just come back to questions he asked you related to your membership in the ACLU, the Southern California chapter. I think we've established that you're a member there. You said you contribute $120 a year. Fine. I just want to go back to these various statements that chapter has made, and my question is not, why did they make the statements? I'm sure that we can look up what the ACLU of Southern California said in which context. I just want to know your own views on it. I'm trying to figure out, do they speak for you on these matters? That's what I'm trying to ascertain here. So here, let's try this again. They have written, the ACLU of Southern California, that that U.S. policing has historical roots in slave patrols and in the forced dislocation of indigenous youth. Now that's a pretty strong statement. I just want to know, does that represent your viewpoint?
Senator, I do not have knowledge or background in terms of the origins, and I don't know what they were referring to there. I can speak to my experience with federal law enforcement, and I have tremendous respect and have worked closely, respect for and have worked closely with federal law enforcement who I believe uphold the rule of law and serve the public interest every day.
Well, so are you telling me you think that U.S. policing, the U.S. police forces, I think the first standing U.S. police force was in my state, I think it was in the city of St. Louis. Are you saying that you think they might have historical roots in slave patrols?
That I don't know. I know the U.S. Marshal Service likes to state that they're the first federal law enforcement agency founded in the initial Judiciary Act.
My question is, do you think that U.S. policing has historical roots in slave patrols?
I'm not aware of that, Senator.
You don't think that it does? What about this? The same letter says that the presence of police has devastating and discriminatory impacts on tens of thousands of California students. Do you agree with that?
Senator, I don't know the context in which what that's specifically describing or talking about.
But in your own experience, I mean, are they speaking for you here? Do you agree with that?
In my experience, in Fresno, in the Fresno division of the Eastern District of California, on balance, I believe that the police, including the police departments, which our office works with closely, and certainly federal and state and local law enforcement, are a positive influence. Okay, good. Let's talk about ICE for a second, because I know you testified that you've worked with ICE. So the same chapter of the ACLU that you're a member of has said that ICE is not welcome here. They've gone on to say, as part of a package that they devised for children, they released door hangers, posters, and coloring sheets for children that included guidelines for how to use them. The guidelines said ICE agents resort to trickery and deception. Do you agree with that? Has that been your experience, that ICE agents resort to trickery and deception? My experience, Senator, is with working with ICE agents on cases under 8 U.S.C. 1326 and other related criminal immigration cases, and I have found them to be diligent, hardworking, and ethical law enforcement officers.
Okay, good. So I think we've established that the ACLU of Southern California, at least as to these statements, they don't speak for you. I mean, you have the views that you've just articulated.
My views are not are I'm not familiar with all of the ACL's views, but certainly I have independent views.
Okay, good. Let me just ask you about this. You've also been a frequent contributor to the group Act Blue. This is a group that, as my colleagues on this panel have emphasized of late, have supported fundraisers with the theme "All Cops Are Bastards." Have you contributed to any of those fundraisers through Act Blue? All Cops Are Bastards fundraisers?
No, Senator.
Does that represent your view or experience with law enforcement?
That does not represent my view of law enforcement.
Okay. I think that those are helpful answers. I think we maybe could have gotten there a little bit earlier with my colleagues, but I'm glad to hear you distance yourself, frankly, from these statements, because I think those statements are pretty outrageous. And it concerns me a little bit that you're a member of a chapter that regularly, and we're not talking about one thing, we're talking about multiple letters, multiple projects, multiple issues over years from this particular chapter. But I'm gratified to hear you say that they do not represent you on these matters.
Thank you, Mr. Chair, and greetings to all the nominees today. I'll begin my questions by asking, as I do for all nominees that come before us, by asking about diversity in our federal courts. I'd like to hear from each of you if you agree with my premise that diversity in all its forms helps strengthen the federal judiciary, number one. If you don't, give me your reasons, but if you do, then please share, if you're fortunate enough to be confirmed, what you might do proactively to advance diversity in your courtroom. And we'll start with Judge Austin.
Yes, Senator Padilla. I absolutely agree that diversity is important in particularly in chambers, the diversity of ideas, thought, just thinking of things differently. My two law clerks are here with me today, and they're a lot younger than I am. So a lot of times their thoughts are, more in line with what's going on in the world today than maybe mine are. So just having conversations and being able to allow them to disagree with me. They have no problem overturning me in chambers, and I have no problem with that either. But I do also agree that having diverse candidates as clerks is important. I know it was important in my life. I got to clerk for a district judge, and from there, I know opportunities opened for me that probably would not have been open if I had not clerked for a judge. So I'm definitely committed to opening up that opportunity to minority clerks, diverse clerks in my chambers as well.
Thank you. Judge Becerra.
Thank you very much, Senator Padilla. I don't have a lot of regrets in my career, but one of them is that I never clerked. And I didn't even realize how important clerking was and how much it could shape your career until I was a judge and hired law clerks. I do think that diversity in all aspects is important in your chambers, because I do think that it enhances public confidence in the judiciary. I also think it's important to have diverse experiences. Just like Judge Austin, my clerks are younger and they have different perspectives and have different life experiences, which I always appreciate. And I also think it's important, not just with the law clerks. I have lots of interns. I have interns every semester. I have interns in the summer. The more people in chambers, I think, the better. I reflect that I think it's difficult to become something you've never seen. I, for example, in my entire career only appeared before a judge that was like me once, and that was in 25 years of law practice. So the more that as a chambers we can be out there touching the community and touching young lawyers, I think that's very important.
Thank you, Senator Padilla. I do agree that diversity in chambers and on the bench is important. I did clerk, and it was a springboard to a very successful career. And I certainly believe that my experience clerking not only opened doors for me, because it's impressive on your resume, there's no question, for law firms. And, your judge usually is able to, people take the call when the judge calls. So they're able to help you through your path. For me, I want to make sure that all different individuals from different backgrounds, and when I have a different background, I mean not just racial, socioeconomic, ethnicity, but also I like to see law clerks from different, with a business degree, with a philosophy degree, from a different law school, from a different state. All forms of diversity enrich my chambers, my practice, and also hopefully enriches the legal practice in our community, because now we've got these individuals with this background going into these hopefully very successful careers.
Senator Padilla, I completely agree with the prior comments in whole, and I would also add, during the last 12 years, I've been the general counsel and chief legal officer of a very large business that operates in 2 states, and I think that not only do I agree with everything that you said, Senator, I think that my own practice, what I've seen, we would hurt our company if we did not consider everything that you said. And I think, I hope that if people evaluated my last 12 years, they would say that I actually acted that way in the importance of diversity and giving everyone a fair shot, and not just racial diversity or national diversity, but all kinds of diversity. Let me add one last thing, which is I think that your comments not only apply to clerkships and interns, if I am so fortunate to be a judge, I think it also applies to receiverships, special masters. I think the public doesn't, at least when I was in New York practicing as a prosecutor, judges have a tremendous amount of power to simply anoint someone and say, you're the head of the class. And I think that when you're thinking about the kinds of things that your question asks, I think that it applies to that as well. Thank you, Senator.
I totally agree. I am very supportive of diversity in the legal profession. I've given a lot of talks throughout the course of my professional career talking about the importance of diversity, diversity on the bench, and also, again, diversity in the legal profession. It is important to not only have the idea that you want to promote diversity, but to go out into the classrooms, to go out into the universities, and to go out into the law school specifically, to talk about the importance of diversity and also having those clerkships. I don't think, in my experience, the clerkship opportunities are promoted as much as they could possibly be among people who are diverse, and so that is something that I do make a point to do, to go out and work to really, sadly, sell the importance of clerkships. It is a wonderful experience. I, too, am the beneficiary of clerkships. Judge James Whittemore, and Judge Chris Altenburn, those are now my lifelong mentors, and they really, have just given me so much in terms of my professional career, and I work to do the same thing. I try not to meddle too much into my law clerks' lives, but I just, I adore them, and I really want to see them be successful. And it's something that I think is unique to clerkships. And the only other thing I'd add is it's important to have those interns as well. Not only the law clerks, but you do need to have the interns so that they can groom their professional career, groom their experience in law school, and work to tailor it so that they can be competitive in getting a clerkship.
Senator, I also entirely agree with your premise. I think diversity of backgrounds and experiences makes, having folks from diverse backgrounds and experiences makes our institutions, including the judiciary, stronger. I think it enhances public confidence in the judiciary. And in terms of law clerks, I benefited from the opportunity to have a clerkship early in my career, and I saw how much that helped me, and I recognize how that can advance folks. I certainly feel, first, that diversity, background and experience among law clerks would be important and contribute in an extremely positive way to the work of chambers. I also think that outreach to students and schools to ensure that we're getting the wide range of applicants from different backgrounds and experience would encourage diversity in that context with law clerks.